Hello and welcome to Property Money Trees Maximising Property Values, the once a month show where I break down the steps of how to recognise, enhance, and then extract the values in property in order to create wealth. Would you like to find out how you can benefit from the steps of maximising property values? This is even if you don't own a property yet or have a deposit. If that's a yes, then you're in the right place to find out. My name is Patricia Ogunfaber, and although many know me for my work as a solicitor, on this show you will be getting the benefit of my 30 plus years worth of experience of maximising property values, experience which has given me a net worth in millions. So who might benefit from listening to this show? Literally anyone with an interest in creating property wealth. Welcome back. What I want to do before the Renters' Rights Bill of 2024 becomes law and therefore becomes the Renters' Rights Act is talk to people about the few things that they might be able to correct in their lettings businesses in order to not fall foul of the legislation that's coming in order to not be trapped with tenants that are going to cause them headaches going forward. So that is the series that I want to start now, and I'm going to start with Section 21 notices, because as everyone who listens to this podcast should be, well, this podcast series, I suppose, should be aware of, is that with the Renters' Rights Bill, ASTs, assured short-hold tenancies, are going to be abolished, and with them will be abolished all the rights and obligations, whatever they might have been. They're also going to be abolished once ASTs get abolished. Now, one of the main advantages, if not the main advantage of an AST, was the possibility of the landlord to ask a tenant to leave, no questions asked. So that is normally referred to as no-fault evictions, because you didn't have to state that the tenant was in fault. All you did as a landlord was have to want your property back. And effectively, when it came in with effect from early 1989, so ASTs were introduced in the Housing Act of 1988, and that particular piece of legislation came into force in early 1989. So at that time, what the government did, because it wanted to encourage ordinary people to become landlords in order to increase the private rented sector, because that had been decimated because of the Rent Act of 1977, which created sitting tenants and you couldn't get your property back and all whatnot, which is the period that we're about to go into again. But anyway, so back in the late 80s, when this was being debated in Parliament, the whole idea was that, do you know what, if you're a landlord, don't worry, you can get your property back, no questions asked. If you want it back, all you've got to do is give your tenant 2 months notice. So that right was enshrined in Section 21 of the Housing Act of 1988. So when people talk about Section 21 notices, that is exactly what they mean. So that will go once the Renters' Rights Bill becomes law. Now, it isn't yet law, which is why I'm doing this podcast right now. So if you need your property back, no questions asked, now is the time to actually serve that notice, a Section 21 notice. And a Section 21 notice is also actually a prescribed notice, meaning that you've got to use, no, you don't have to use the government's form, but if you use any other form, it has to have all the information that's on the government form. So it's a lot easier and safer to actually use the government's form. Now you can get this form, I think it's form 6A, and you can get that on the .gov.uk website. So if you just search section 21 notice .gov.uk, it should take you to the right page. You can download the form, you can enter in the details, and you can serve it onto your tenant. Now that sounds very, very simple, but it isn't quite as simple as that, because there are certain situations where you can't use a section 21 notice to regain possession of your property. So what are those scenarios? So the whole essence of this podcast is that if you need to serve a section 21 notice, serve it now before it's too late. If you've served a section 21 notice and you're not sure it's valid, take advice and make sure that you serve a valid section 21 notice, because if you lose this opportunity, it will be gone forever. Now, what are the scenarios in which you might want to serve a section 21 notice? One, to do with the tenancy itself. Is the tenancy a bit dodgy? You've not had it properly drawn up for you, and so it contains various loopholes, various things that will come back to bite you in the future. Or what about the tenant themselves? Are they a tenant that are very high maintenance, a tenant that you probably don't get on with, a tenant that probably doesn't like you? There's no point in having a relationship that is going to be fraught with difficulties. There really is no point. It's not good for the tenant and it's not good for the landlord. So those kind of relationships, I think, are best terminated, because there's always a perfect landlord for every tenant, and I'm sure there's a perfect tenant for every landlord, but it just may well be that the particular tenant that you're thinking about right now you're not the perfect landlord for them, and they're not the perfect tenant for you, and the property is not perhaps the perfect property for them. So those kind of relationships, you really do want to be reviewing them now, because as landlords, as responsible landlords, I think most of us want to provide a really good property for our tenants, and we want them to be happy in the property. Now, there are some people, there's nothing you can do, you cannot make them happy, and there are some terrible landlords, don't get me wrong. I'm not saying that every landlord is a responsible landlord, I am not saying that, but what I'm saying is, regarding responsible landlords, there are certain tenants that are just not the right tenants for you. Anyway, so those are the kind of reviews that we need to be doing now, whilst we've got time still to serve a section 21 notice. Now, serving a valid section 21 notice does not mean that you're actually going to get your possession easily, no, because chances are anything served around about this time may well be challenged in court, just to see, if there's nothing for the tenant to lose, especially if they don't want to leave or if they want to cause you aggro. Because if they can get the courts to actually throw it out, then you're literally stuck with what the Renters' Rights Act is going to provide, meaning that you can't get your property back unless you can actually fit in to one of the possession grounds. Now that I'm going to do in another podcast, because they are actually quite detailed and there are quite a few of them. And the people who need to be particularly vigilant. So if you are an HMO landlord, you will not be able to rely on the ground that says you want to actually live in the property. And that in itself actually applies to literally all buy-to-let landlords, because when you take out a buy-to-let mortgage, one of the conditions is that you and nobody from your family is actually going to live in that property. So if you then say you want the property back because you want to live there, or a member of your family wants to live there, I think you're going to be challenged in court,
to say, well, why are you using this ground? Because you agreed with your lender that you will not live there and nobody from your family will live there because you've got an unregulated mortgage. So, and all buy-to-let mortgages are unregulated, all of them. So be very, very careful. Be extremely careful. And so with a lot of buy-to-let landlords, you will still have the option of saying you want to sell the property if you do. Now, if you want to sell the property, again, you can actually do that. You can serve a notice on that basis, but be mindful that you will not be able to let the property during a restricted period. A restricted period will be 12 months from when your 4-month notice expires. And that notice can't be given during the first 12 months of a tenancy. So just bear all of that in mind. It's quite detailed. I'll be doing another podcast on this. Now, for HMO landlords, if you give notice and say you want to sell, where does that leave you? Because most of us know that once we give notice, some tenants will decide they're not paying rent anymore. And unless you have provisions in your ASTs, your existing ASTs, which will become defunct once this bill becomes law, because they'll be stopped immediately and every single tenancy is going to move and become an assured tenancy. And so all of these restrictions as to what landlords can and can't do will become applicable then. So with an HMO, I guess you can say, yes, I'm going to sell, but you have to now think about it. Do you want to sell your HMO? If you do want to sell your HMO, then yes, that route will be available to you. But if you are just disgruntled because of a particular tenant, do you want to be selling the whole business because of one tenant, when now if you were to act, you might be able to evict that tenant? So these are the kind of things that I'm trying to get people to think about. So also, you cannot use a Section 21 notice if you're trying to use it within the first 4 months of your AST. So it can only be used with ASTs. If you don't have an AST, this is not relevant to you. So just forget about what I'm saying. Just stop listening. So during the first 4 months, unless your tenancy allows you to do it. Also, if you have a fixed term tenancy, you cannot use a Section 21 notice during the fixed term, again, unless your tenancy allows you to do so. Also, if it's an HMO and it's not a licensed HMO, you will not be able to use a Section 21 notice. Are you in a selective licensing or additional licensing area? Have you got your licenses? If you haven't, boom, boom, boom. Yep, you know what the drill is and you know what that means. If you've received a deposit after, I think it's sometime in 2007, I can't remember when, kind of like first quarter, second quarter 2007, and you've not protected that deposit, again, you cannot use a Section 21 notice. Now, if you've received a deposit and you've not protected it, you can pay it back to allow you to issue a Section 21 notice. So all of these things, they're relevant for when you actually issue that Section 21 notice. What about if a council has served you with an improvement notice? So if your property is in disrepair and it's classed as like serious disrepair, so you've got mold, you've got broken windows, blah, 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 and you've been served with an improvement notice, you cannot serve a Section 21 notice within 6 months of you being served with an improvement notice. What about if the council has told you that they will be doing emergency works on your property? Again, you cannot serve a Section 21 notice. Then you cannot. And if in the last so again, for that, it's 6 months. So if you, any notices from the council to do with, the state of your property within the last 6 months, you cannot serve a Section 21 notice. What about if you have received unlawful fees? So what are unlawful fees? So the Tenant Fees Act of 2019 tells you what fees are allowed. If you've received anything that isn't within, that act, which is not a permitted fee, you have to return it in order to be able to serve a Section 21 notice. If you didn't serve an EPC, so that's an energy performance certificate, on the tenant or prospective tenant before they became a tenant, you can't use the Section 21 notice. What about the How to Rent guide? Did you serve it before the tenancy? Electrical Installation Condition Report, EICR. Gas safety certificate, did you serve it before the tenancy? So these are the things which normally would apply for you to not be able to, or be able to, serve a Section 21 notice. However, there was a case to do with gas safety certificates, and that case said that as long as you serve the gas safety certificate before you issue your Section 21 notice, then that's absolutely fine. The name of the case is Tresserell House Limited versus Roundsfield, and that's a 2020 case. So in the Tresserell case, the court said as long as you serve it before the Section 21 notice. Now, that case wasn't about a landlord not having the gas safety checks done. It was about not serving them when they ought to have served them. So just again, be aware of that. Now, with HMOs, what you can do is you could have a notice which says, all your certificates are actually here, and you could have like a folder in the communal area saying, all your certificates, safety certificates are here, and if you'd like a copy for yourself, please do get in touch with me. Again, that will be okay. But if you haven't got any of those, you might not be able to serve a Section 21 notice. So it is very, very important that you do your reviews now to try and make sure that you will be okay if you actually need them. And I will do something else next month to do with what you might want to be doing now before the bill becomes passed as law and it becomes applicable to every single landlord. But hopefully see you next month.